Hello everyone and welcome in today's video. I am Sohini Biswas, a third year law student, and currently I am doing an internship at the LEXIS and Company. Today I will be discussing on the topic of the doctrine of res subjudice under section 10 of the CPC. So let us begin. Subjudice is the Latin term means under judgment. When two or more cases are filed between the same parties on the same subject matter in two or more different courts, the competent court has the power to stay proceedings of another court. The doctrine of res subjudice aims to prevent courts of concurrent jurisdiction from simultaneously entertaining and adjudicating upon two parallel litigation with respect to the same cause of action, same subject matter and same relief claims. Now, what is the object of res subjudice? The doctrine of res subjudice grants power to the court to stay the proceeding of the trial where the subject matter in issue of the same proceeding as the previously instituted suit between the same parties, and the court where the suit is previously instituted has competent jurisdiction to pass effective order or grant a relief that is sought to be. This rule is applicable to the trial of a suit and not to the institution of suit thereof. However, the doctrine is applicable to the appeals and revision under the provision of the code. It does not restrict the court to pass interim orders which include an injunction or stay on the suit, the appointment of receiver, etc. The object of this doctrine under the provisions of the CPC is to preclude courts of competent or concurrent jurisdiction from simultaneously adjudicating the two parallel suits where the subject matter is the same between the two same parties sought to achieve the same relief. Therefore, the main objective is to avoid multiplicity of proceeding and minimize the frivolous litigation and unnecessary delay in judgment. Now, let us understand this with the help of some case laws. First, in the case of Guru Prasad versus Vijay Kumar, the court held that the rule does not prevent the court from following any court procedure to adjudicate the suit together, which would serve the ends of justice. Thus, it is the fundamental to note that the rule of res subjudice merely lays down a procedure that has to be followed by the court. It is not an inherent legal right of the party. That is, it does not mean that getting off order of staying of suit is an absolute right of the party. Now, what is the scope of this doctrine? The stay of the suit as envisaged under section 10 relates to the trial and not proceeding. The court which has stayed the suit would not lose its control over the suit or proceeding, and it continues to administer the said suit, including the proceedings, except to the extent of laying its hand for the conducting of the trial. What are the conditions that must be fulfilled? First, there must be two pending suits, one previously instituted and the other subsequently instituted before the court of law. Second, the subject matter in the previous instituted suit must be directly and substantially related in the subsequent suit. Third, the party or the legal representative in the pending litigation must be the same. Fourth, the jurisdiction of the court must be same for the previously instituted suit as well as the subsequent suit. Fifth, the court where the suit is previously instituted must have competent jurisdiction to grant the relief claims in the subsequent suit. Last but not the least, the parties who are litigating must possess the same title in both the suits. However, it is noted that the court has no power to be barred the institution of a subsequent suit but can restrict its trial only. The final adjudication of the former suit can be brought under the res judicata in the subsequent suit. Now, let us understand this with the help of a case law. In Neeta versus Shiv Dayal Kapoor and others, the court held that the subsequent matter cannot be stayed if the condition mentioned in section 10 are not fulfilled. In the apparent case, the two courts which tried the same issues were not the courts having the concurrent jurisdiction. Therefore, the proceeding in the subsequent court are not to be stayed. Now, what is the conclusion that we can derive? With the increasing number of frivolous and respective suits in the Indian judiciary, it is necessary to strictly implement the doctrine of res subjudice. The main objective of this doctrine is to avoid the multiplicity of suit and unnecessary delay in providing justice to both the parties. Thus, it helps parties to avoid unnecessary filing of the same evidence in different courts. The doctrine also helps in reducing conflict of decision between the two competent courts and minimizes the waste of resources of the court. Therefore, this doctrine is significant in the Code of Civil Procedure to fasten the justice system and deliver and reduce the workload of the overburdened Indian courts. However, it is necessary that rigorous application of this doctrine should not end the subject and the substance of justice. Thank you.